Joining us today here for the second panel on the relationship between competition and innovation. I couldn't be happier for having the opportunity to moderate this panel on a topic that is really close to my heart and to the heart of the OECD Competition Committee. We had the opportunity to already discuss this topic at the Competition Committee twice last year. And because we still think that is a very complex topic and that there's a lot to talk about, we decided to have this third conversation today with our excellent panelists. In a first discussion that we have in June last year, we focused on a theoretical relationship between competition and innovation, what were the main drivers of competition, what were the main drivers of innovation, and if they at all have any relationship from a theoretical perspective. Then in December, we went to the other side, to the enforcement perspective of this relationship, and we had a discussion with our competition authorities, the delegates, where they shared some experiences, different approaches on how they consider innovation in competition enforcement. So today, my goal is that in 1 hour, we get to put both things together and have some takeaways of the discussion. So because 1 hour is very short and the topic is complex, let me just do a very short introduction of the experts that are here sitting next to me and go straight to the first question. At the end of the panel, we're going to have some space for taking questions from the floor. So please feel free to ask them. And to the people that are joining us online, there's also the option to ask questions on the chat. Next to me, we have Stephen Lewis. He's a partner at RBV Economics in London with significant experience in the assessment of innovation in mergers and abuse cases, in very prominent cases where innovation has played a key role, such as the Google abuse of dominance cases in the EU. We also have Christine Varney. She's partner at Cravat, Swain & Moore. She served as an Assistant Attorney General, headed the Department of Justice Antitrust Division, and she served as Commissioner of the FTC. And we also have David Teese. He is the Thomas W. Tusher Professor at the Institute for Business Innovation at the University of California, Berkeley, has a School of Business and co-founder of Berkeley Research Group. So thank you all for being here with us. I'm going to kick off the conversation with the first question to Stephen. Stephen, you have been reviewing what's going on with the relationship between competition and innovation, both from academic perspective, but also from the enforcement cases where you have taken part of. Where are we now in this discussion? How close is economic theory to the developments on enforcement?
So thank you, Aura. And first I've got to say what a privilege it is to speak at the OECD with such esteemed panelists. So thank you very much for this opportunity, and thank you for inviting someone who doesn't have their own Wikipedia page. I'm very much the odd one out in that respect. I'll do a brief disclosure and a disclaimer. I think you mentioned that I've advised Google for many years. I think I should also say I'm advising them on the DMA, which will come up later. I also assisted on the Dow-DuPont merger, which I will talk about as well. RBB advised on the Illumina Grail, which will come up, but I didn't work on that myself, so my knowledge of the case is fairly limited, and obviously all the views I'll express today are my own. I'll start with the theme of mergers, and I think later on we'll move on to some of the other areas where issues around innovation and competition arise. So I think I should start by saying that worrying about the effect of mergers on innovation makes a lot of sense. Innovation is critical for society for many of the reasons that Matthias said in the opening speech. And I think it's also absolutely the case that innovation lies squarely within the consumer welfare standard that was discussed in the last panel. And according to economic theory, mergers can have an impact on innovation. And I think there's a role for innovation theories of harm in merger control. And I'd agree with the general view that strong dynamic competition drives innovation. The difficulty for authorities is figuring out which mergers are pro-dynamic competition and which mergers are not. And when we come now to the theory, the problem is, depending on which economist you ask, you'll get a different answer on the strength of the conclusions it's possible to draw from economic theory on the impact of mergers on innovation. And I think there's a range of views on this across academics and practitioners alike. The case that really brought to the fore the debate about the impact of mergers on innovation, at least as far as practitioners are concerned, is Dow-DuPont, but obviously the debate goes back much longer than that. This was the first case where the Commission went beyond analysing competition in well-defined pipeline product markets and considered the impact of the merger on overall levels of innovation, which would presumably affect competition in unknowable future markets. I won't say too much about the case itself, but just a little bit about the economic ideas in the debate that the case triggered. So the decision in Dow-DuPont takes a fairly hard line on the impact of horizontal mergers on innovation. It roughly says that innovation is just like price competition, and absent efficiencies, theory predicts a negative impact when two firms merge. And the mechanism whereby mergers reduce innovation is that pre-merger, if one firm successfully innovates, it will steal business away from its rival. So if the firms merge, you can imagine that head office of the merged entity takes into account the actions of one business unit on another business unit, and this leads head office to demand a decrease in overall levels of R&D investment. And this is very similar to the reason why price competition in theory gives rise to negative impacts absent efficiencies. And this has been discussed in economic literature on innovation, going back at least as far as Arrow in the 1960s. But there's an alternative view which in the academic literature, which is that the theory is not so clear-cut. It says, yes, this business stealing effect is an important insight from economic theory, and this may well drive a reduction in innovation incentives. However, there are also other important effects, and this is not necessarily a pro-merger view. This is not a view that says, don't worry about the effects of mergers on innovation or expect them to be benign. It's a view that says, we need case-by-case assessments, and that requires a complex balancing of different influences when it comes to innovation. And we shouldn't start this assessment with a very strong negative presumption about the effects of mergers on incentives to innovate. So to see how this debate has played out, it's helpful to start by asking, why might a merger increase innovation? And the most obvious answer is through changes in the combined entity's ability to innovate. So research synergies, coming from bringing together complementary assets and complementary know-how. And these might be a very important consideration for thinking through the impacts of mergers on innovation, but let's leave so-called efficiencies to one side for now because they have a special status in merger control, which tends to mean they're the last consideration rather than the first consideration. And that word efficiencies, I think, we'll come on to talk about why that might not be a very useful word when we talk about innovation, but it's just a term of art in competition law. Instead, let's ask, how might a merger increase innovation, even absent a change in the merged firm's ability to innovate? So purely looking at incentives. Now, least controversially, there could be knowledge spillovers. If a firm successfully innovates, it might make it easier for its rivals to innovate. And these positive knowledge spillovers tend to mean that firms put too little effort into innovation from a societal perspective. A merger can internalize this positive externality, and this can mean that head office post-merger calls for an increase in innovation efforts. And this spillover idea is fairly uncontroversial in theory, although, of course, there'll be debate in practice about whether it's a relevant consideration on any given case. And, for example, the Commission in Dow-DuPont thought this was not a relevant consideration. So the heart of the debate, and I think the key controversial question, is the case where there are no knowledge spillovers and low efficiency. So can a merger, horizontal merger, increase innovation even absent efficiencies and even absent knowledge spillovers? And there are some important academic contributions in recent years that point out that yes, they can. And I'll give a flavour of some of these ideas. First, under quite realistic assumptions, the ability of a merged entity to reduce innovation efforts in one research unit and can give rise to an incentive to increase research efforts in another research unit. And this can give rise to an overall increase in the level of R&D investment and also the rates of innovation. And this is demonstrated in a paper by Di Nicolo and Polo. They show that horizontal mergers may actually spur innovation, and this is more likely when the innovation is of greater value and when returns to R&D investment don't decrease too rapidly. Second, if a successful innovation by one firm can enhance the output of another firm, this increases the scope of the application of the new technology and increases its value, and therefore the incentive to innovate. And this isn't the same thing as a research synergy, because it's not about how the merger impacts the ability to do the innovation or the probability of the innovation, if you put a certain amount of effort in, that the innovation will turn out to work. It's about how the merger impacts what you can do with the innovation when it's done, and how that in turn impacts incentives. So like knowledge spillovers, this is a consideration about incentives rather than ability to innovate. And these contributions are pointing out that the circumstances where mergers increase innovation might be broader than just the case where the merger improves, gives rise to some sort of synergies or knowledge spillovers. Although these are, of course, very important issues in and of themselves. So the summary of this view is that the analysis of the impact of mergers on innovation is not quite the same as the impact on price effects. There are parallels for sure, but innovation is much more complex, and the analysis requires a balancing of opposing effects that affect the incentives to innovate. And given that the assessment and the standard for assessing efficiencies in merger control is extremely high, it's important that we don't tilt the assessment by saying that any plus factor for innovation should be put in the efficiencies box, where obviously the standard is very high, because some of the plus factors for innovation are actually incentive issues. They affect the incentive to innovate rather than the ability to innovate. So I'll pause there, and maybe we can say a bit more about the treatment of efficiencies later and how, obviously, a very important issue in innovation.
Thank you so much. It seems that there is a lot of work going on related to incentives, ability, knowledge spillovers, and that perhaps Dow DuPont, as you mentioned, was one of the pioneer cases where innovation played a key role, at least as a separate theory of harm. In the US, there's also the Illumina Grail case. So thinking about it, Christine, what is everyone doing to better understand this relationship, and how does this translate into the most recent enforcement cases?
Thanks so much, and again, it's a great pleasure and honor to be here. As I was discussing with Chairman Ginny, it's been 30 years or so that I've been coming here, so it's wonderful to be here once again. But it's also been 30 years that we've been talking about innovation, as led by then Professor Thies. In the 90s, there was a merger between Ciba-Geigy that created the pharmaceutical giant Sandoz. And in that merger, back then, we talked about the innovation that was happening between those two companies in a search for a cure for blood cancer. And what we did at that time, and I was at the Federal Trade Commission at that time, was we allowed the merger to proceed because we saw a huge opportunity for innovation, but required that one of the two competing approaches to the blood cancer cure be spun off, and indeed both approaches eventually came to market. What we're seeing in the United States right now is really innovation and merger enforcement. That is, I think, beyond doubt. I do want to remind everyone that I represented Illumina, so my remarks today are completely my own, have nothing to do with anything that the company would or would not say. I'm also going to limit my remarks to the United States, as there is still active litigation in the EC, so I want to be very careful that there's no misconstruing from where I speak. A number of you have stopped me in the hallway and in rooms this morning and said, how did this ever happen? So let me, if I may, just give 2 minutes on what happened here, and then we can spend just a couple minutes talking about how innovation fits into this. Illumina founded Grail several years ago. Illumina was doing research, and they found in the research that they were doing that several of it was for prenatal testing, and they were seeing cancer markers in what they thought were several of the fetuses, and they believed that they were seeing a high incidence of cancer in fetuses. What happened was that when those babies were born, none of the babies had cancer, and 100% of the mothers did. And Illumina realized very quickly that if you could determine and detect cancer very early, that it would be the holy grail of the cancer fight, because early detection certainly means to a much higher ability to save lives. So Illumina also realized that it was going to take an enormous amount of money to bring what they had inadvertently discovered to full, scientific review, development, and eventually to market. So they decided to spin Grail out, retaining I think at the time it was about a 12% share in Grail. Spun it out. Fast forward to a few years ago when Grail decides that they need to raise a lot more money in order to jump through the final hurdles to get to commercialization and market, and Illumina decides to buy them back. This was before President Biden was elected. It was in the last days, I think it was in October, before the election when the merger was announced. And in the United States, we were still, for the most part, in a very traditional merger analysis, a traditional vertical merger analysis. So the merger went forward, and the Federal Trade Commission decided that they, under President Biden, that they were not going to accept the merger. Simultaneously, and I won't comment on it, there was a lot of activity happening in Europe, much to everyone's surprise. I'm sure there have been many panels had on Article 22 and the exercise of Article 22 jurisdiction, but this was the first instance of that jurisdiction being exercised, and I think it caught everyone by surprise. There was a lot of procedural back and forth, as you all know and remember in the United States. If the Federal Trade Commission wants to stop a merger, they must go to a U.S. district court to get a court order to stop a merger. So the Federal Trade Commission had filed in court to attempt to get an injunction to block the merger. And then they withdrew their request for an injunction. Specifically, I think they believed that what was happening in Europe was sufficient, that they did not need to move to prevent the acquisition or the reacquisition of Grail by Illumina. Illumina made a decision to go ahead and reacquire Grail when their timing ran the course in the United States. There was no bar in the United States to reacquiring Grail, and so they did that. Therein ensued most of the saga, where the Federal Trade Commission put the Illumina Grail merger into a trial, an administrative trial with an administrative law judge. And what's very interesting there, I think, is you can think about the Illumina Grail transaction in kind of three different frameworks. Was it an existing market for R&D in multi-cancer early detection testing, or what we call MCED testing? Was it a potential competition market for MCED products? Or was it an innovation market where one of the parties to the merger had a dominant upstream position that could potentially be used to foreclose alleged rivals downstream? I think how you think about this merger really drives where you come out on whether the merger was potentially anti-competitive. I think it's also clear that in the United States, there is a clear, well-stated, well-articulated agenda that consolidation is harmful. It is harmful to consumers, it is harmful to workers, and it is harmful to the economy. That, I think, was a major driver in how the United States authorities viewed this merger. What was interesting is that in the actual trial where the judge, the trier of fact, had over 50 witnesses that came before him that he questioned directly, as well as the party's lawyers questioned him. The judge concluded in the case that there was no evidence to show that there was harm was imminent or probable, as there were no realistic competitors to Grail. If there were no realistic competitors, there could not be harm. The judge based this finding on the fact that, well, multiple parties, Natera, Guardant, Thrive, were all in the process of developing different types of cancer detection. None of them were remotely close to where Grail was in its process of getting government approval. One of the markers that we talked about back in the 90s as a way to evaluate, a tool you could use in these kinds of mergers, how far along were parties in getting the necessary approvals. None were there. None had anything remotely close to a 50 cancer test. The others had 3 cancers, 6 cancers at the most. One was maybe going to be able to get to 8. They all had different methods. What they all did rely on was the Illumina platform. Illumina does next generation sequencing, and these putative competitors relied on Illumina for their platform. The trial court found that Illumina had no financial incentive to disadvantage putative rivals because the profits that Illumina would reap downstream from multi-cancer early detection testing were at least 15 years away. And that if they maintained, as the trial court found, that Illumina had a dominant position, if Illumina maintained their dominant position, which was not clear, that they would continue to reap profits from all cancer testing that ran on their platform, and that they had no incentive to discriminate or foreclose these putative competitors where the judge found that there was no basis to believe that there was imminent or probable harm. In our system, what happens next is that trial court finding gets reviewed by the Federal Trade Commission. First time ever has happened, the Federal Trade Commission rejects the finding of the trial court on this matter, on the merger. They have rejected a trial court before on consumer protection matters, on investment matters, but not on a full-on merger. And it was interesting because where the trial court had found that there were no putative competitors, the FTC assumed there were competitors and then went on to address the harm. And the FTC, the opinion states, because there are competitors at various stages of development, Illumina will have the incentive to harm those competitors. They won't be able to innovate. Very interesting, right? So the trial court, trier of fact, says there's no putative competitors, and therefore there can't be harm. The FTC assumes they're competitors and therefore focuses on the harm. Then we get to the Court of Appeals, and the Court of Appeals, in what is technically a loss for the FTC, but has been roundly portrayed as a victory, says, look, we, the trial court, we have to accept that the FTC believes that they're our competitors, and we find that they applied the right standard in evaluating the potential harm to competition. However, they did not take into account the remedial effects that the parties have offered, and therefore they remanded the decision back to the FTC, and that's where it stands today. So picking up on how we think about innovation, one of the key factors, I think, in the Illumina case was that there was what we call real-world evidence. Illumina had previously acquired a different company a decade ago that did what we call non-invasive prenatal testing, NIPT. And when they acquired that company, they were able, this is when you're pregnant and you don't want to go through very invasive types of testing, there are a number of alternatives. Illumina got that company, they accelerated its development, they brought it through the approval process at the FDA. And in our system, as is foreign to most Europeans, you have to pay when you get medical care. You can't get private insurance to reimburse a medical procedure until the government, Medicare, Medicaid, agrees to reimburse. So our system is you've got to get FDA approval, then you have to get Medicare, Medicaid reimbursement, and then it becomes commercialized because private insurers will cover it. Well, Illumina bought an NIPT company, which was running on its platform. They successfully commercialized that test and lost market share. Why? Because they innovated. They got the government approvals, they got the insurance reimbursement. That allowed competitors to enter the market and commercialize their products, and they simply had better products, better marketing, whatever reason you believe. Illumina lost market share in its prenatal testing after it went through the whole process and competitors gained market share. So we do see that this merger had a tremendous potential innovation benefit. The authorities disagreed. And I think it points to the fact that in our system now, and we don't know that it will stand, we have a presumption that mergers are anti-competitive. And it is the burden of the parties to demonstrate that any merger, and this one was vertical, obviously it was not horizontal, that any merger has some type of pro-competitive effect that will rebut the presumption of the negative impact of consolidation. So it's a very tricky time in the United States. My own view is that if there is a change in our administration, you will likely see the new merger guidelines withdrawn, and you will likely see the 2010 merger guidelines reinstated, which give, I think, a lot clearer guidance about how to think about these kinds of mergers. The current merger guidelines are not a surprise. They are exactly what this administration has been articulating, the way that they view and evaluate mergers. They're completely accurate, as in that is what this administration has done. They've had very limited success in the courts, so it will remain to be seen how much U.S. authorities will be able to dive into the nuance of both the pro-competitive and anti-competitive effects of mergers on innovation.
Thank you very much, Christine. You just did a great job summarizing with one single case many of the challenges that competition authorities face when they try to incorporate innovation considerations in their assessment, challenges on market definition, whether we can actually approximate innovation just at looking at R&D efforts, investment, expenditure. Should we go further and look at the innovation spaces as the Commission did in the Dow-DuPont merger? And also, how do we assess incentives and ability to innovate under uncertainty and under a longer-term perspective that innovation requires? You also touched upon many of the issues that competition authorities have stopped thinking about because perhaps the legal frameworks, in your case you explained the US, do not allow them to go further and look at other aspects of innovation, perhaps through a more dynamic perspective. So I want to turn to David and ask, well, David, you're considered the pioneer of the dynamic capabilities perspective, and you've been discussing what are the kind of things that competition authorities and academia should look at to kind of understand more and incorporate more innovation into the competition considerations. So I want to ask you, what do you think is missing to fully capture innovation? What is it that we are still not understanding, and how can we go further in this debate?
Well, thank you for that invitation, and thanks for being here. And Senator Monti pointed out that one of the things the OECD does is a catalyst for new thinking. And I must say that the topic of dynamic competition, actually, I think the OECD and Frederick and others were amongst the earliest ones to start talking systematically about it. And I actually began writing about dynamic competition early in the early 80s. You would think I'd be happy to see that finally, after 20 years of not much happening, that suddenly the enforcement agencies are focusing on dynamic competition and we're getting a better system. Well, I'm happy that we're focusing on dynamic competition because, as Schumpeter told us, that was the competition that really matters. The rest of the, simple price competition based on efficiencies and bleeding a few pennies out of the cost of a product, that doesn't really move the needle. What moves the needle in competition is innovation. So this is what we should be focused on. The problem is we're inventing theories of harm faster than we're understanding the innovation process. And why is that so? It's because of us, and when I say us, I put myself in the category of the economist along with Stephen. When I say us, I'm taking collective ownership of the economics profession. Go look at an average economics textbook. There's no treatment of innovation. And if you're lucky, you'll get something added in the appendix or somewhere to the end. But innovation is not the essence of how we discuss economics. So reality is that economics has shunned innovation, not because they don't think it's important. Every economist will say it's important, but because it's hard to model. It messes up the general framework. Microeconomics is based on equilibrium models. Innovation is all about disequilibrium. So most of the tools that we were all taught in graduate school don't work. That means the economists need to be disrupted. Not just the market, but the economists in the agencies, as well as in academia, need to be disrupted. The good news is that there is a very large body of work on innovation in business schools, and it's around strategic management and entrepreneurship. We do have a reasonably good understanding of the innovation process, but that has not yet found its way to the academic literature on innovation and competition. And for the reasons I indicated, because neoclassical economics doesn't know how to absorb it, because in fact it is radical and it will tip over, 2/3 of what most economists think is a correct view of the world. So where does that leave us? Well, it leaves us with the following. First of all, we need to double down on understanding the innovation process itself. We all understand it's about deep uncertainty, and of course there's very few models of uncertainty in economics. Risk and uncertainty are very different things. But most importantly, we should remember that the key aspect of innovation is that it's combinatorial. Just think about that. Brian Arthur wrote an excellent book on this about 20 years ago. Just about every innovation is a combination of another innovation. And when you're thinking about mergers, maybe mergers is one of the mechanisms by which this combinatorial activity takes place. And I'm not saying every innovation requires mergers, but many do. We're not going to create a metaverse without lots of mergers. There's a lot of technologies that are combined using mergers. And if we start with a presumption, I think this was both what Christine and Stephen were saying, the mergers are bad. You're making a presumption against the very essence of innovation itself. So that is one thing that we have to bear in mind. There's many other things that we have to bear in mind as well. And a critical one is what matters is more than incentives. Economists have got one thing right. They understand the importance of incentives. But it's not the only thing that motivates businesses, and it's not the only thing that explains business behavior. But you would think that it is, based on the analysis that you read. If you look at, economic analysis of mergers and acquisitions, 98% of it is about effects on incentives. You're in a business school, sure, incentives matter, but missions matter, strategy matter, organizational design matter, organizational culture matters, lots of other things matter too. And I would be the first one to say, if you get incentives, if you don't understand incentives, you don't understand what's going on. But I'll be the first one to also say, if all you understand is incentives, you won't understand what's going on. So we have to, as economists, get beyond incentives. And the key place to go is capabilities. And the problem here can be summarized in the following way. We cannot do merger analysis or monopoly analysis without a theory of the innovating firm. There is not a theory of the innovating firm in economics. We have production functions, we have production sets. We don't have a coherent theory of the innovating firm. If you did create a coherent theory of the innovating firm, core to it would be the role of capabilities. And in fact, there's quite a bit of research out there early on. Edith Penrose's book on the theory of the growth of the firm points out that capabilities are foundational to what firms do. In competition policy, we start with markets and product markets. But we're learning, and this is a good thing that's happening, I think, with the discussion around dynamic competition. People are now talking about future markets. Well, every business student knows about future markets. They know that what a firm is currently doing is just an expression in time of what it can do. And in times of war, for instance, you see General Motors stop, makes cars and makes tanks the next day. Companies can do different things with the capabilities they have. But if you analyze just product markets, you're not going to get to the right answer. You're not going to see what matters. And so if I want to be just a little bit optimistic, I will say that discussing these questions has at least opened the area of inquiry. And even though I don't like Dow DuPont, there's at least a discussion about avenues of future research and about future competition. And I think that to answer those questions, you have to understand firm capabilities. If you're going to know where the firm is going to compete in the future. If firms don't have revenues now, you can't analyze a product market. It doesn't mean that you can't analyze competition. It's just that you're going to have to analyze future competition, and to do that, you're going to have to look at capabilities. Now, you go to an economics textbook and look in the index and see if you find the word capabilities. You won't. So how can economics inform this analysis? And I'll also give you some optimism. If you looked in the economics textbooks about coordination 30 years ago, all you found was cartels. Now you've got a much richer treatment of coordination and cooperation. There's more to cooperation than just cartels. But I think we need to build a theory of an innovating firm around understanding capabilities. And there's three basic classes of capabilities. I've written a lot on this myself. There's what I call ordinary capabilities or superordinary capabilities and dynamic capabilities. And you can project where a company is likely to go, or at least you can get a feel for potential competition, at least, by looking at the capabilities they have and whether they're able to direct those and redirect those capabilities. So if we actually dig into this, we'll end up with a decent theory of potential competition. It's absolutely pathetic. There's not one single paper on potential competition that's moved the needles for 50 years. You would think we would be able to do better. Why aren't we doing better? Because we're stuck with neoclassical economics, that if an economist can't find a simple model to do something, they figure if you can't model it, it doesn't exist. The real world exists. Models are just our effort to try and summarize and simplify. But we're not doing that well, and we've got the wrong tools, and so we need to do a multidisciplinary effort here. There's clearly a role for economists. I'm one of them. I understand the importance of incentives. But there's also a role for understanding and a need to understand strategy, organization, culture, missions, all these other things. And I think smart people in the agency sort of know this. And when you let them go, sometimes they get there. But it's sort of like pushing things uphill when it should, in fact, be at least an even surface.
As David said, I think the real world is calling for faster thinking. Last week at the International Conference on Competition in Berlin, Commissioner Vestager talked about some of the challenges that the competition authorities are facing, for instance, when reviewing digital mergers. And she talked about the use of new theories of harm related to future potential competition in innovation-driven markets, for instance, in the Adobe Figma merger. And this also has a lot to do with future markets, with considerations on dynamic efficiencies, capabilities, and how they are assessed by the competition authorities. You mentioned it previously, Stephen, and I want to ask you, do you see that there's still a gap there, that the competition authorities are starting to consider these dynamic competition aspects in their reviews?
I think so. And just to come back to some of the points that David made, I mean, I did my undergrad in economics and management. And so management was part of my undergrad. And I can tell you that David is absolutely right, that some of the really important things that I learned in my undergrad about resource-based view of the firm, dynamic capabilities, I was reading papers by David in the early 2000s when I was an undergrad student. That doesn't come up again in my graduate training in economics, and it doesn't come up again in my career as an economist. There is, at least I know what I don't know about this field, but I think most economists don't even know about the literature that David's referring to. So I fully agree there, and I think there's going to be fruitful grounds for kind of cross-fertilization from that literature if we want to really understand dynamic capabilities, how competition in future markets might play out, and how we can judge who are going to be the firms who are going to be the competitors in those markets. And coming back to kind of digital mergers, I think you're absolutely right to point out that as an area where this is going to be a huge challenge. I think there's a general sense that authorities are dialing up enforcement and scrutiny of digital mergers, and even if that's warranted and the right way to go, the question is how will authorities get the balance right going forward? And there's a whole session on digital mergers later, and I don't want to encroach on that too much. But it's obviously a critical topic when it comes to innovation. And I think first thing to say is that the digital sector is an area where innovation synergies are likely to play a very important role. And I think this is a mainstream view. I think it's a finding in two major reports into the digital sector in recent years. I have in mind the Furman report in the UK and the EU Special Advisor report in Europe. The Furman report says most acquisitions by large digital firms are benign or beneficial, and the EU Special Advisor report says they may frequently bring about substantial synergies and efficiencies. And yet, on the other hand, we have a situation where justifying a merger on the basis of synergies before the European Commission has proven to be very difficult, even in cases involving traditional concerns around price effects. The Commission has never justified a merger on the basis of efficiencies that it would have otherwise have prohibited. So in a setting where the concerns around innovation incentives, the task becomes potentially virtually impossible. And the reason why that is, I mean, firstly, compared to static cost reductions, dynamic efficiencies that improve innovation prospects are likely to be harder to kind of prove in the way that the Commission expects to see efficiencies being proved, and they're likely to occur over a longer time horizon. Secondly, even if the merging parties can point to kind of concrete increases in their abilities to produce certain innovations as a result of bringing their complementary assets together, this is a real change in their ability to innovate. How does one balance this against a concern around a reduction in incentive to innovate, particularly if that's coming from a starting point of presumption that, as Christine said, we are seeing now presumptions around reductions in incentives to innovate as a result of mergers. And the nature and impact of synergies in the digital markets can be very hard to predict. And just to give one example, it's been reported that DeepMind, AI research, reduced Google's data center cooling bill by 40%. And this would have been very hard to predict ex ante. No one really would have been able to say before that merger that that's how the merger is going to impact on something as concrete as a data center cooling bill. And while you could just to come back to one point about the relationship between this concept of kind of static cost efficiencies and innovation. On the one hand, you could look at this as this is an innovation that leads to a static cost efficiency. But there's a relationship between static cost efficiencies and more dynamic innovation incentives, because if I can do some innovation that reduces my marginal cost of production, this can give rise to a greater incentive to do some innovation that gives rise to the ability to expand demand, because I've now got a lower marginal cost of serving that demand. So there's a complicated relationship between static cost efficiencies and incentives to innovate. Second, there's a question about how we account for ex-ante incentives for venture capital firms to provide funding for innovative startups in anticipation that the startup will be acquired, and how those incentives get incorporated into an analysis and how they get impacted in an environment of stricter merger control. It's a complex issue. It's raised in both the Furman report and the EU Special Advisor report. Third, I think another thing that economists miss is the importance of human talent as the ultimate scarce resource when it comes to producing innovation. And I think we overlook the role that plays in motivations to acquire certain startups, and also what it implies for the roles of counterfactuals, particularly when we're assessing the question of would a firm just go and build that asset if it couldn't acquire it. And I'd be happy to elaborate on that further if there's time. Finally, the difficulties may be compounded in cases where the source of the synergies and the source of the competition concerns are the same. So if a firm is acquiring a complementary asset and it can show that it can make use of this complementary asset to create some innovation that improves its core product in some way, can the merging parties be sure, can they rule out the possibility that the authority will be concerned that this will make it harder for others to compete with the core product? So could firms be in a bind whereby if they could demonstrate some dynamic efficiency, allowing them to make a significant product improvement, this leaves them open to an efficiency offence? And just to be clear, I'm not talking here about an acquisition of a firm that could potentially give rise to its own competitive threat on the core product. There's a clear framework for thinking about those kinds of cases. I'm talking here about a pure complement, where if I buy that complement, I can improve my core product in a way that potentially has benefits for a very large range of consumers. Of course, if we're in a market with network effects, that's going to make it harder for my competitors. And there's a suggestion in the US horizontal merger guidelines, that kind of efficiency would not be taken into account. We'd be concerned about the enhanced difficulty of my rivals to compete with me if I get this product improvement. So even if we should err more on the side of competition, as Tirol, who was mentioned earlier, has said, we need to take seriously the possibility of over-enforcement errors, particularly when you consider that both the Furman report and the EU Special Advisor report recognise the fact that many acquisitions in digital markets give rise to innovations that propagate product improvements to a very large base of consumers. So this is not a scenario where type 1 errors or over-enforcement errors are costless.
Thank you very much. Stephen and David just gave us some ideas for things to start considering a little bit more when analyzing innovation. Christine, you wanted to react to that, and I want to know your views on this.
Well, it's interesting because if you look at Google, for example, and you look at all of the acquisitions that Google did over the years, DoubleClick, YouTube, ITA, it plays into exactly what David observed. The enforcers started with a product market definition and said, Google is not in those markets. Therefore, there is no problem with those acquisitions, and all of those went through. I think now the government is moving in the United States much closer to an examination of what does the digital acquisition mean in terms of the overall market dynamic? What does it do to dynamic competition? So I think we're beginning to see a realization of that, but it does tie back to, in the United States, we still have laws on the books. We still have judicial precedent, and you do start merger analysis with market definition. And as you all know, product market definition is essential. So we're going to have to kind of bridge that gap when it comes to innovation. The other thing I would point out is that the innovation discussion is focused so much on the digital markets, and it drives me insane because there's so much innovation in, for example, healthcare. And the biggest example that you see of that all the time that is in such contradiction with the way we're looking at mergers in the US, most of the really fabulous, innovative healthcare startups are, a dozen scientists in a room who figure out some new breakthrough in cardiovascular disease or in musculoskeletal disease or in oncology. They do not have the capacity, the interest, the ability, the time, the commitment to bring that breakthrough to market. They don't have a sales force, they don't have distributors, they don't have the ability to go through clinical trials. Who are they going to get bought by? A company that, one of the major incumbents that is in oncology is going to buy the oncology breakthrough. A cardio company is going to buy the cardio breakthrough. The presumption that the incumbent is buying the innovator to prevent the innovator to come to market has just factually been proven wrong. Those innovations come to market because the incumbents buy them. And we have to somehow, cross that gap as well.
Yeah, Christine, you're exactly right on that. This is this whole question of nascent competitors. Most people in the agencies have no clue how difficult it is to scale a company. With this hand here, I practice a little bit as a venture capitalist on the side. I got 4 or 5 companies, and I've built several and taken a couple public. This is really hard stuff. And the assumption that some person in the agency, I see this little company there, it can become some gigantic company, whether Giphy or whoever it is, and take on the giants. You need resources, and particularly in the case you pointed out, those people don't want to actually build a company. Exactly. So, do you have the management team together? Do you have the capital? Do you have the mission? There's all kinds of things that you have to tick the box on before you can say that this is a potential competitor. And the naivete with which economists and the agencies are looking at this is really quite shocking. I guess we'll all learn in due course. And as part of that learning, I want to see the elimination of the term dynamic efficiency. I know we've all used it, but innovation and efficiency are often enemies. If you want to innovate, you're not going to focus on efficiency. Yes, eventually, because of innovation, you end up doing things more efficiently. But the process of innovation is not one about looking for efficiencies. Henry Ford with the Model T became very, very efficient, so efficient that when competition showed up, he didn't have an alternative car, and he had to shut the Ford Motor Company down for 6 months to a year and create the Model A Ford. So there's this tension here, but the reason the economists use it is they want to pretend that, well, this is just the efficiency analysis they've always been doing, rather than stepping out, doing the hard work, learning the literature, getting their sleeves rolled up to understand what innovation really is about. So eliminating dynamic efficiency, call it maybe dynamic efficacy or something like that, because it's not efficiency, but it's an excuse to roll forward the tired learnings of the past and not do what the OECD is encouraging us to do, which is to think afresh and anew about these new complex problems.
I want to go back to Christine, because you said that competition authorities are starting to do a little bit more to consider innovation. So you mentioned we're seeing that the American authorities are updating guidelines, that the EU is starting to use Article 22. So I wanted to ask you, do you think that we are going in the right direction to consider more innovation?
I think it's always the right direction to consider innovation. I don't think the new U.S. guidelines do that. So it's a bit of a split answer. I think when you're looking at innovation, within the context that David has just explained, we do have tools to think about innovation. There are mergers. I think in the United States, Visa Plaid was an example of a merger where an incumbent was buying a nascent competitor to kill it. The evidence showed that. There was plenty of evidence that showed that. And when you can distinguish when you're looking at nascent competition in order to do a merger in order to prevent a threat to your incumbency, there's usually pretty solid evidence. What I think is troubling is the presumption, the speculative theory that a particular merger or transaction will lead to innovation harm. I think you have to go back to fundamentals. You need to go through the exercises, even though they're need to be updated. But we do have exercises that can help us determine when a merger is likely to retard innovation and when a merger is likely to accelerate innovation. The problem is that we're looking in the United States, we're looking at mergers in one basket. And it's very sincere, what our regulators are doing. In the United States, in the Biden administration, there's a sincerely held belief that the biggest threat to American democracy is income inequality. There is a sincerely held belief that consolidation contributes to income inequality. Whether you agree with that or not, whether the evidence, the empirical evidence supports that or not, that is a widely held belief articulated with great regularity. So what it does, it puts us in kind of an agenda-driven, and I didn't like an agenda-driven antitrust enforcement when it was driven by the right, which is all mergers are good, but I don't like an agenda-driven enforcement by the left that all mergers are bad. I'm much more go back to the center, and I think we will. Antitrust enforcement tends to kind of swing back and forth, at least in the United States, and I think we'll see it get back to the middle, where we will think about what is the effect of an actual incumbent acquiring a nascent company. I don't want to say competitor because they're not always competitors. Does it accelerate that product, that technology, that software coming to market, or does it kill it? And that is, I think, a pretty reasonable framework to think about nascent competition.
David, you were mentioning that, as evident, economic theory still needs to do a lot in terms of innovation. So I wanted to ask you, where else can we, and particularly competition authorities, look at to equip themselves with the tools to consider innovation and to look at it into a more broader perspective?
Well, some of these tools have to be created, but some don't. As I was thinking about Dow DuPont, and at the end of the day, they looked at patents as an indicator of capabilities. Well, it's a very poor indicator, but we can think about ways to measure capabilities, and there is an emerging literature on that. So So I think there are places to go, but at the same time, I don't want to say it's all out there and it's just a matter of porting it across. Hard work has to be done to change the paradigm, basically, so that we can come to grips with these issues. And as Christine pointed out, this is not just about letting more mergers through. There are some bad ones, no question about it. But the presumption, we don't have enough knowledge to have strong presumptions is where I'm at right now. Maybe a decade from now, when we understand things, we can strengthen our presumptions, but the presumptions that mergers are bad. My presumption is they're pretty damn good because I know that the essence of innovation is new combinations. And if someone tells me I'm going to stop something, which is the essence of innovation, my antenna goes off. But none of the people in the agencies have probably read Brian Arthur's book or studied economic history, where you'll see that that's the nature of innovation.
Make one more comment in. I do want to be clear. I don't think any of us are talking about, old industrial mergers where widget manufacturer number 2 buys widget manufacturer number 3 in a very consolidated market. That's probably a bad merger, and that's not what we're talking about here. What we're talking about is those very difficult mergers that really do involve cutting-edge technology, innovation, nascent competition, and trying to determine when that is beneficial and when that is not. I think we have to move away from presumptions, and we need to be much more rigorous in our thinking.
Yeah, and actually, the notion of innovation spaces, I think that's not a bad idea to start thinking about. But when you think about an innovation space, you've got to be alert to all the potential players that can come in. You mentioned Grail. Well, I happen to be on the board of a company that has a blood test for cancer about the end of the market. It's got nothing to do with genetics. And so it would fall outside of the competition lens that was used, but it's going to blow Grail away, I believe.
Please God. All the tests out there are great. More tests, better.
Before moving to the questions from the floor, I wanted to ask Stephen, what do you think we're going to see in the near future regarding innovation in competition enforcement?
Okay, so I think now's a good moment to move away from mergers, if that's okay. So I'll maybe one comment. I'll just say that I fully agree with David that this language around efficiencies is, I think, potentially unhelpful. Unfortunately, it's there in the sort of legal material. It's there in the kind of merger control guidelines and everything, but I fully agree that when we talk about efficiencies in competition, we're talking about something very different potentially to what business people are talking about, which is, for them, efficiencies is marginal cost reduction and not, introducing the next, bringing together complementary assets that give rise to the ability to produce new products. So I'm going to talk a bit about tech regulation because I think that's also an important topic when we're thinking about innovation and competition. I think today is the day that large tech firms have to be compliant with the DMA. So it's a good day to discuss the implications of tech regulation for competition and innovation. And clearly, the debate moved on a few years ago from should tech firms be regulated to how should tech firms be regulated. And the DMA is the EU's answer to that question. The UK has come up with quite a different looking answer, and it's quite useful to compare and contrast these approaches and consider the implications for innovation. So both the UK and EU approaches have innovation as a stated goal. Before focusing on innovation, it's worth just sketching out what these approaches are in broad terms. The UK will have a pro-competition regime for digital markets, and we don't know what the interventions will be, but we do know the high-level objectives. And crucially, we know that the CMA is seriously tooling up its capacity to do evidence-based research of digital markets. It's been very busy hiring economists and technologists and building its data science team. And we've had samples of what to expect from the CMA on a few cases, the very impressive digital ads market study and their ongoing work in relation to privacy sandbox with Google, which I think Sarah mentioned earlier. And the CMA has said it sees its recent cases in digital as a blueprint for tech regulation in the UK. And it said it will take a pragmatic, evidence-based approach, seeking to ensure interventions are focus on well-identified competition issues and recognizing where there are trade-offs with other objectives, of course, privacy being one of them, which was mentioned earlier. In the DMA, on the other hand, we have a list of form-based rules, and crucially, the rules are the rules. If a firm is found to be violating them, there's no defence available that the conduct generates benefits for consumers. It's not that the burden of proof has switched from the authority to the tech firm to show there's no adverse effects or to show benefits to consumers. It's simply that competitive effects and consumer benefits are not considerations when it comes to assessing compliance with the DMA rules. So these are very different approaches. And the difference is not necessarily about one approach being more interventionist than the other. Some of the rules that the CMA may ultimately come up with could be more intrusive than the DMA rules. But the DMA is clearly a blunter instrument than the more flexible and targeted approach that the UK is pursuing. And I think one of the implications for this is that the DMA brings more scope for unintended consequences when it comes to innovation. And to illustrate this, I want to talk about one particular aspect of the DMA in a bit more. So the aspect that I'll discuss is data openness. So data openness involves mandated transfers of data between companies which the consumer has no control over. So it's very different to the concept of data mobility, which typically refers to consumer-led data transfers. And the essential problem that data openness is trying to solve is that in some markets, data can be a potential driver of competitive advantage, where the idea is more data from usage allows a firm to improve its product, allowing it to attract more users and thereby gather more data. And in the extreme case, this data may be essential for competition. So mandating access to data could be a sensible way to open up competition and encourage further innovation. But there are clear downsides for innovation and for privacy as well, but that's not the topic for now. Data openness is one of the topics in the EU Special Advisor report that I've already mentioned. The report makes the point that mandated open access to data could give rise to negative consequences for innovation. And I think the EC Special Advisor report really sets some homework for regulators to really dig into how data openness should work in practice and how to design any data openness intervention in a way that the benefits would outweigh the costs. And I would expect the CMA to be gearing up to do this kind of thinking, to do this kind of analysis, and to analyse these kind of complex issues in some detail. But the EU sort of pressed ahead, really, with data openness when it comes to search data. And Article 611 of the DMA mandates, in a fairly sweeping way, open access to, on FRAN terms, to ranking, query, and click data. This is going to affect Google. So this imposes a duty to supply data to competitors. Now, this might increase competition and innovation in search, but it's also possible that an intervention like this has the opposite effect. And the basic concern is that sharing data of this kind could lead to rivals becoming copycats rather than independent innovators. And this is not a hypothetical concern. In the past, when Bing had access to a little bit of click and query data via a setting in Internet Explorer, it used it to copy Google search results. So what this shows is that even with a relatively small amount of data from a rival search engine, the result can be copying of results. And this happened even without ranking data. So the assumption in the DMA that access to data increases innovation incentives on the part of rivals could be very wrong. It's possible that what access to ranking data and click and query data means in practice is that rivals get enough data that they can reduce innovation efforts and stop innovating, or even stop innovating in search completely. So to give you a kind of an analogy, it could be like Bing becomes a lazy school kid that copies the answer off a hardworking classmate rather than thinking carefully for itself. And eventually, of course, Google could stop bothering to improve its search results too. And this is a danger that's explicitly recognised in the CMA digital ad study, which states that this kind of invention could dampen incentives for Google to innovate, since any further benefits would be shared with rivals. Now, this is all great if your objective is to make more equal the market shares of search engines. But I think that misunderstands what we want from dynamic competition as a driver of innovation. Yes, we may want to improve contestability in search, and choice screens for search engines are one of the ways that the DMA is seeking to achieve that. But we also want firms to be able to appropriate the benefits of their innovation efforts. And making the largest innovator in search share its ranking with rivals could undermine that. So crudely, sure, Bing might get a higher market share, but in the worst case scenario, you could go from two independent innovators, Google and Bing, to one. We go from a situation where there's a small guy playing catch up, trying to keep the big guy on their toes, to a situation where you've essentially got one innovator and the other one copying the results. And so if there's no independent innovator behind Google on the track, then any improvement in its ranking automatically get conferred to its competitor, then it's hard to see why there's much of an incentive to keep improving, innovating in search. So data openness is an example of an area where I think the kind of research that the CMA is gearing up to do before designing its interventions is absolutely critical. The CMA may well end up going down a similar route to the EU, but I expect them to do a lot of research and think very carefully about how these things should be designed before they do that. And one sort of observation that struck me is that it's quite telling that while innovation is a stated goal of both the EU and the UK approaches to tech regulation, there are quite subtle differences in the language around how this is expressed. The EU objective is to make it easier for smaller companies and startups to enter digital markets, innovate and compete. Whereas the language around the UK approach is more neutral as whether the greater hoped for innovation comes from the smaller companies for whom hopefully there's opportunities from greater contestability, or the large tech firms themselves being pushed by smaller companies. And this might seem like a subtle difference, but it could give rise to some kind of practical differences in approach. So to conclude, even if we want to see more contestability and authorities are going to intervene to achieve that, we need to be very careful and evidence-driven when it comes to making interventions that could quite radically change the way that competition in a market works.
Thank you. As you all see, there's a lot going on all around the world. Still a lot to be done and see. At the OECD, we will be looking closely at these developments. What is clear for me, at least from this conversation, is that innovation is taking a more prominent role in enforcement and also in academia, particularly when reviewing mergers, but also in different aspects of competition. Perhaps we will need soon a fourth discussion, but I'll give time just for one question from the audience, if anyone has a question. It's a microphone.
Thank you very much. I'm Alban Kwakam, president of One & Co Consulting Group. Christine mentioned the fact that Joe Biden or Biden administration is very concerned about inequality. Joseph Stiglitz highlighted the fact that market concentration, which lead to mega profit, are one of the cause of inequality. I would like to know from your perspective, as an expert of antitrust, how the Biden policies and his administration regulatory have so far diminished the market concentration, especially in the tech industry. Thank you.
We could have a whole afternoon conversation about that. But in the tech industry, unlike what's happening with CMA and the DMA here, our approach in the United States has been through litigation. So one of the most important litigations, I think, is the US case against Google and the Epic case against Google, as well as the Epic case against Apple, where they're really looking at trying to break the stronghold that both those tech companies have in a variety of sectors, right? In advertising, in search, in app distribution. So in terms of trying to, you know, create more competition and allow, you know, more economic activity. It's really, in the United States, it's a litigation approach, and that's what the U.S. Department of Justice and the Federal Trade Commission are doing.
Thank you very much. Sadly, we ran out of time, so let me thank you for your excellent insights and everyone for being part of the panel. Now, one of the most expected moments of the day, the lunch break. Please enjoy and make sure you're back at 2:45 for yet another great panel on algorithms and competition.